have Cheryl Bruner. Cheryl is an attorney, and her specialty is really planning. And often there's so many questions about estate planning, advance directives, living wills, those sorts of things. So Cheryl is very well known in the community. She's a committed community person, and that's who we like to support, for folks that have really invested in Louisville and in the senior community. And Cheryl has done that. So thank you so much for being here with us this afternoon.
Thank you, Mary.
Yeah.
Okay, thanks again for being here to learn about this topic. We know that adage that sometimes you have to hear things a few times before it sinks in, so I doubt this will be the first time that you've heard a lot of what I'm going to say, but hopefully it builds on your existing knowledge, and you leave here knowing something that you didn't know when you came. So that's going to be my goal for you. I can stay after we finish if you have a one-on-one question that you'd like to ask me, but I also welcome questions as we go, because it could be tiring to listen to just the same person for an hour speak. I do like to say I'm from St. Michael, so my husband and I have been members out there in J-Town at St. Michael for 25 years almost, so that's our home parish. And I know lots of people who have loved ones come here to Nazareth, and I imagine a lot of you are in that situation as well. So when I'm in my office giving examples to families, I'll say, for example, at Nazareth home. So I use that example often because, even as Mary pointed out, everyone would like to stay in their home, but sometimes it's just not practical. So I'm going to demystify and teach you a few things, and we're going to start with what is estate planning. And hopefully you picked up a packet as you came in, so these are copies of my slides as well, which might help you be able to see some of that better. But if you look at these points, and any of these things, any of these bullet points resonate with you, I want to be able to take care of my property while I'm alive. And I want to have my financial and medical affairs in order if something happens to me, if I become disabled. And I want to give what I've been blessed with to the people, to the organizations that I want, when I want, maybe during life, maybe after I pass away. And I might even have some assets that I would like to protect in case I need long-term care down the road. And I'm a private person. I don't want my business all public. I want to keep things private. And I certainly want to avoid unnecessary costs, taxes, delays, fees. So if any of these things are how you feel, that's what putting an estate plan is all about. You put this together to help with all of these areas. It's not just for wealthy people. I'll have some folks come in my office and ask me the question, well, I don't need a trust because I don't have enough money, right? That's not the case at all. And so I'm going to talk about those details later, and you can see what all these different methods of estate planning can do for you and do for your family. Okay? All right, so did you know, though, even if you haven't prepared any documents yet, you already have an estate plan. Well, how's that? How do you have an estate plan? There's a state law out there. Now, do you think you want what the state has written down, or do you think you want what your own wishes are, right? Do you even know what the state plan is? Does anybody know? What if you passed away, you had no documents saying who gets what? What would Kentucky's law say happens? What's a guess? Somebody guess something.
Closest blood relative.
Closest blood relative. That's a good guess. And that is about half right. So, some people assume, well, won't your spouse get everything? Well, that's about half right. So, typically, let's say you're a married person and you have a lot of assets that are just in your own name and you have no plan whatsoever. Well, your spouse will get half and your kids will get half. And you think, well, that's not exactly the plan that I want. So if you don't want the state's default plan, you need to have your own plan in place. But every state has a law like this. So this is why we say estate planning is for everyone. And there's lots of different ways to go about things. Okay, so I'm going to start with your last will and testament. I didn't skip one, did you? No, okay. So a will, a last will and testament. Same thing. Am I on the right slide? I'm seeing you all change page. No? Not the same slide?
No, POA is first,
Huh.
but we can follow.
We can follow. All right. Well, we might have to pivot. So on the slides that you all have, the POAs are next. Well, let's talk about that. I've done this presentation enough. All right. So a power of attorney. We say oftentimes a power of attorney can be even more important for some people than a will. So a power of attorney is a document that has an impact only while you're alive. The moment you pass away, the power of attorney ceases to have any authority at all. So only during your lifetime. Sometimes you might hear them called durable. What's that mean? A durable power of attorney means it's in effect now, and even if you become disabled, it stays in effect throughout your incapacity. Sometimes you might hear them called springing, which means it's not in effect right now, it only comes into effect if I become incapacitated later. So there's different kinds. Again, this is another area. Every state has a law. Kentucky has a law about what a power of attorney can say, should say, what can be covered generally, what must be covered very specifically. So there's a lot more to it. If you have a power of attorney now, and let's say it's 2 pages long, it probably covers about 90% of what you might need. All right, where's the teachers in the room? 90% is not bad. But what if you need the 10%, right? So there are certain powers in a power of attorney that must be spelled out very specifically, and that's according to state law. So there's a little bit more to a power of attorney document than you might have thought or realized. Durable, springing, and what are the specific powers that you put in there. Another common misconception I see is sometimes people think they can only name one person, and then they can name someone else as a backup. And that certainly is a common way to do it, but you don't have to just name one person at a time. For instance, for my dad right now, me, my brother Jeremy, my brother Kevin, all 3 of us are on his power of attorney. And we are serving jointly, independently, or the survivor of us. And what that does is it gives us some flexibility. Maybe I've got a lot going on and I need my brother Kevin to step in and help Dad, or vice versa. So you can name multiple people who you trust to serve at the same time. And that can make it easier sometimes on your kids if they're the ones that might be helping out, for example. Okay, go ahead, ask a question.
Well, it's not a question, it's a comment.
Okay.
And it's probably exactly opposite of what you expect. But having worked in the field of elder abuse and exploitation, the most effective way, if you want to steal every penny of mom's money, is to pressure her into making you the power of attorney. And then you've got free will. And if she doesn't have a dementia diagnosis already, not much anybody can do about it. And I've had victims where everything is gone because the child used the power of attorney. Now, power of attorney is critically important, but I always say, make sure you're very careful when you name your power of attorney.
I agree. And it really has to be someone who you trust.
Absolutely.
Another example to deal with that type of issue is you might name 2 people and say that they must serve as co, where it's going to take the agreement, decision, signature of both. That can be a real hassle for certain financial institutions, but that's why it's very important if you're meeting with an attorney to help you with your documents, it's very important to get to the bottom and explain what your concerns are, what your family situation is, because there's not a one-size-fits-all on anything I'm going to talk about. There are very customized solutions according to what your goals and your concerns are. Okay, so power of attorney. Now, I think the next one is my healthcare documents, isn't it? So, healthcare. In my practice, we basically have 3 different healthcare documents that we do. One of them is the general healthcare power of attorney. Now, you might see this lumped in with the financial. Sometimes people put it into one. I do them separately. You might want your daughter to be on one, and you might want your son to be on the other, so that's one of the reasons I handle them separately. So the healthcare, who is going to make decisions for you if you cannot make them for yourself? Because you get to make your healthcare decisions until you can't. So this might be you're going in for a surgery, or you're going in for some testing, or there's just been an emergency. You know, who's going to make those healthcare decisions? That's another one where you can list it a variety of ways. Multiple people. You know, you want them to make decisions jointly. You want decisions to be unanimous agreement. We can really customize these things. Another document is your HIPAA authorization. HIPAA is a federal law that protects the privacy of your medical information. So who do you want on your list who can have access to medical information? This became a little bit bigger deal during COVID when the hospitals were closed to visitors and you had to call to get an update about your loved one. So who do you want on your list? So that's the HIPAA authorization that we prepare. And then the last one is the Kentucky Living Will. This is a form. I bet you've all been asked about it, haven't you? When you've gone to the hospital. Do you have a living will? Is it on file with us, right? Wouldn't it be nice to say yes? Yes, I have one, and yes, it's on file. So this is a form that the state of Kentucky has issued. We use the same one. We just retype it so that it looks like the rest of the documents. You can get it on ag.ky.gov. That's the Attorney General website for the state of Kentucky. There's a really nice living will packet. You don't have to pay a lawyer to do it or anything. You can just print it out and sign it with witness or notary and have a valid living will. So you can say yes to that question. Okay, so those are our basic healthcare documents. Healthcare power of attorney, HIPAA authorization, and a living will. But there are more than that. Mary used the word advance directive. We see that sometimes listed in the document, and it's typically synonymous with the living will. It's where you're saying in advance what I want to happen in certain healthcare situations. And there's another new form that lots of states are starting to develop and issue called a most form. Have you heard of this one yet? I think the law in Kentucky was just passed last summer for this form. So this is not a form that you fill out in your lawyer's office. This is a form that you can complete with your doctor. Let's say that you have just received a diagnosis. Maybe it's MS. Maybe it's Lou Gehrig's disease. Maybe it's Alzheimer's. You can meet with your doctor and fill this form out to detail the types of treatment you want, the types of treatment you don't want. So it can be very detailed and very specific to what your diagnosis is, and you fill it out with the doctor. So that's a new one, the Kentucky MOST form, M-O-S-T. I'm trying to see if I can remember what that acronym stands for. I think it's something like medical orders
for life-sustaining treatment.
Thank you, medical orders.
It's called the POST.
The POST?
Physician orders for life-sustaining treatments.
Okay, thank you.
And we complete those here. We like to have with everybody what we call a goals of care conversation, so we can understand what you would like from us and the people around you.
Yeah. Oh, thank you. I'm so glad you knew more about that than I did. Okay, so that's new, and you can see there on top of it. Let's make sure if your loved one is here, let's talk about what we're going to do, what we're not going to do. All right, so very good. So that kind of covers that healthcare topic. Does anybody have any questions right now about the healthcare issues? Anything on top of your mind?
Do you have a living will? and you decide to change your mind about how it's written, do you need to go back to where the original one was, or does it just go by date? If you make a new one,
That's a good question. So she's asking, if you do a subsequent one, do you have to get rid of the old one? Do you have to go back to the same person who prepared it? Things like that. And your point about the date. The date is what's going to control. Typically, these documents that we're discussing say, I revoke all prior living wills. I revoke all prior powers of attorney. They typically say, I revoke the ones in the past, and here's the one that I'm issuing now. However, if you've given copies to someone, how are they going to know that you've updated it? So you might have a little bit of work to do to go replace, at your doctor's office perhaps, or your specialist office, or maybe you've given your children a copy of something. So it's something to keep in mind if you've given copies out of any of your legal documents. Yeah. Any other questions on healthcare right now?
There was a move to try to allow nurse practitioners to sign the most, but it hadn't been approved through the do you know if that ever got approved, or are we still stuck with just a physician sign?
I don't know the answer to that. I'm wondering, do you,
I think that was the reason that it's in instead of P.
Okay.
But, I think there does always remain in the state of Kentucky some bit of tuggle about who can write what. So at the end of the day, a physician would sign it. Here, often the nurse practitioner is the one who has the conversation with the family and the patient, but then ultimately the attending physician would sign that.
Remember the days when we all used to have a physician, a doctor, an MD?
Yeah.
And now we've got nurse practitioners, which are good, I like it.
Yeah, me too.
It's different.
Okay, yes.
Could you address the do not resuscitate form?
Okay, a DNR. You can't get that in your lawyer's office. Sometimes I have to explain, this living will is not the same thing as a DNR, right? If you're living in your home and somebody calls 911, what is their job to do when they get there?
Take you in.
Keep you alive and get you to the hospital, right? So if you are still living in your home and you feel like you want to be a DNR, the typical way around the state that you coordinate that is through your local EMS, your local fire department. I have seen it personally where people will have this taped on their front door and taped on their refrigerator. And that's kind of where to look if the emergency responders come to your home. Because their job is keep you alive and get you to the care. So that's a different thing. Now, of course, when you're in a hospital, or perhaps you move into a long-term care setting, those are more topics that are typically addressed at that time as well, to know what your wishes are and get documentation of that.
And it has to be an original and has to be notarized?
It does.
Yes, it does.
Thank you.
You did on that, yes. Yeah, there's certain legal documents we don't want to mess around with, and the one that is going to take part of whether it's the end of your life now or not, those are the really important ones that need to be notarized and keep up with the original. Many of the documents we'll talk about, photocopies are fine, but we need an original for that. All right, good. Okay, let's go to this next point. Okay, what is this thing probate? What is probate anyway? So, we like to say, it's the lawsuit that you file against yourself and you have to pay for out of your own money. Does that sound good to anybody? No, it's a court proceeding and you have to pay a lawyer to do it. So many people say, how do I avoid probate? I'm going to get to that. But let me just talk a little bit more about the probate process. So when someone passes away and they've used a will as their method of their estate planning, the will is the instructions to the judge on what you wanted to happen with your assets when you passed away. And we have some excellent district court judges here in Jefferson County. So none of this is about our judges, they're great. It's the process. The process of going through probate court after someone passes away typically takes at least a year from when the person passes away. So it's slow. Everything is public. The will becomes a public record. Then 60 days later, you have to file an inventory of the person's assets. That becomes a public record. You know, how much is paid to the lawyer? How much is distributed to the people? All of those things become part of this public process. So early at the beginning where we talked about is privacy important to you? Probate is not private. It is very much a public process. It can be expensive. You think you're having to pay a lawyer to take care of things for over a year? That sounds expensive. So a lot of people really do want to avoid that. So let me get back to a little bit more about the will, your last will and testament. The instructions to the judge. So if you have a will at home, I want you to go home and look at it. Make sure you have the original. This is one where the original is imperative to keep up with. See if there are 2 witnesses and a notary. Okay? Because in Kentucky, if you want your probate to go smoothly without extra steps, you need to have the original will. It needs to be signed by the person who's passed away with 2 witnesses and a notary on it. So go look at yours. If it's missing any of those elements or you can't lay your hands on the original, your family is looking at extra steps or possibly even the will not being accepted. And I've had that happen a couple of times in the last few years where the folks only had a copy. They didn't have the original, couldn't put their hands on it. And the people who might benefit otherwise would not agree to use the copy. So the will was not allowed. And so if the will's not allowed, what happens? Well, then we go back to the state law. Well, what does state law say about where all of this goes? So if you're going to have a will-based plan, have the original and make sure it complies with all those requirements that Kentucky has. Okay? Any questions about the will right now? Can't really see those myself.
Let me turn the light back out.
Oh, no, it just seemed a little blurry anyway. I can look at my screen on this. So, you know, in a will, you nominate who your executor is. That's the person that's going to wrap up your affairs for you, the executor. If you're female, it's called the executrix, which is one of the weirdest words in the English language, I think. So that's who's going to wrap up your affairs for you. You can make bequests. Those are specific gifts. And then there's the residue, which is the rest of it. So you might leave a specific gift to a charity and then leave the rest in equal shares to your children. That's a common type of setup that we see people do in their wills. Now, what if you lived in another state and you had a will there and now you live in Kentucky or Indiana and you're wondering if your will is still good? Well, if it was valid where you entered into it, it should be accepted here. I've had cases in our office like that before where we just had to show the judge that the law in this particular state said that this is how a will should be done, and we showed that that will was done that way. But it might not be smooth. It might be an extra step, which means it's an extra cost. So you don't necessarily need new documents if you've moved. Now, a will can also have language that creates a trust upon your death. That is called a testamentary trust. A trust that's created by your will when you pass away. So if you've heard that word before, that's what that means. I don't typically draft things like that because it sends you to probate court and then you have a trust. So to me it seems like we're doing 2 things when we could have just done 1 thing. But there could be a situation from time to time where it seems to make sense for a client or a family to have that. But that's what a testamentary trust is, created by the will. Okay? All right, so let's talk about, you've told us enough about probate. We know we've got great judges. It's a long public process. How do I avoid it? So it's basically about 4 ways that your assets can avoid the probate process, all right? So the first one is make sure you have valid beneficiaries. So your life insurance policy, make sure you've got a beneficiary. Your IRA, your 401k, your Roth IRA, make sure you have a valid beneficiary. We see it often that a married couple will have each other, then when the first spouse passes away, it doesn't get updated. That's very common. So, not only should you have the primary beneficiary, it's a good idea to have the contingent, the secondary. You know, what are you going to do if the primary fails? So, valid beneficiaries keep your assets out of probate court, okay? All right, TOD, transfer on death, POD, payable on death. A lot of the banks will allow you to put that type of designation on your bank account or maybe on your investment account. So it's like a beneficiary on a certain kind of financial account, transfer on death. So let's say that you are the POD on your mom's bank account. That means when she passes away, you go to the bank with her death certificate and your identification, and they see that you're on there, and they write you a check for the balance on the account. Okay, so that stays out of probate court if you have a TOD or POD. Another way, joint ownership, co-ownership. Lots of husbands and wives own their house jointly with right of survivorship on their deed. That means if one of you passes away, the other spouse doesn't have to do anything. You already own the entire house without taking any action at all. Or let's say that your mom's bank account, you are on it as a co-owner with her. And if she passes away, the bank account stays open and you legally own it. Now whether you're going to split it with your siblings is a different question. You legally own it if you are a co-owner on that bank account. So co-ownership is a way to keep some assets out of the probate court process. The last way is to have a trust. If a trust owns an asset, it stays out of the court probate process. So when estate planning attorneys are working with clients, they're looking at what the different types of assets are that you have and evaluating all those different options to come up with what is the right plan for you. What works for you in this situation? So, trust. You probably got the beneficiaries, the payable on death, and the joint ownership pretty easily. So am I good to go on to trust and start talking about that now? Yeah, question?
So, my daughter is the beneficiary on my accounts.
Okay.
Do I have to have I should have a will as well, or a trust?
Okay.
Is it-
So you have accounts and your daughter's the beneficiary. You're wondering, do you need a will or a trust at all?
Right.
It really depends on what other assets you have. It depends on what are some goals or concerns that you have. And with that point that I just made, I am going to talk about some details of that, okay? It's a good idea in general to always have at least a will. Let's say, for instance, that you pass away in a car accident and it was the other driver's fault. Well, then your family may want to bring a claim, a lawsuit against the driver of that other car, and your will would be what would say where you would want the money to go. So if there's a claim concerning your death, a will can come into play. That would be another reason. Okay, so let's talk about what trusts are. Trusts are private. They're contracts. They're just an agreement. If you make a trust by yourself, then you make a contract with yourself. If it's a husband and wife making a trust together, then it's a contract that you all are making with each other and yourselves. It's just a contract, piece of paper, and I can write anything. If you can tell me what you want, I can find the legal words to make it happen. So it's a private contract, a private agreement. The person who creates the trust is called the grantor. And then the person that does the business, runs the things in the trust is the trustee. And then whoever gets the benefits is the beneficiary. So sometimes you would be all of those. My husband and I have a trust together. We're the grantors, we're the trustees, and we're the beneficiaries for our whole life. Okay? That's very common. One thing that a trust does that's like a will is it says where you want your assets to go when you die. That's what a will does too, right? But a trust does more. That's pretty much all a will does. A trust does a lot more than just saying where you want your assets to go. A trust can help oversee your property, your affairs during your lifetime, if you become incapacitated, and then after you pass away. It can keep going. So it's more of a continuum type of arrangement where that will is the instructions at a point in time. So that's one way to think about the differences. Another thing with the trust is it permits smooth transitions from phase to phase of life. Have you had the experience before where a loved one passes away and the bank account was frozen? It's typically what happens if you don't have it in a trust. You know that somehow these banks find out you pass away, that account is frozen, and then you gotta wait till you go to probate court to be able to get in it. A trust can prevent that. It can prevent the accounts from being frozen because the trust will have a successor trustee who's going to just step in if the trustee can't do their job. Yes, Doug?
It's a joint account, can they, is that also do that?
So Doug's asking if it's a joint bank account with a husband and wife and one spouse dies. No, it's not frozen. That's one of those benefits of the joint ownership, the co-ownership, is that would not be frozen. Yeah. Okay, so trusts give greater flexibility and more options than having a will. And one of the things that many people like about that is that trust administration, the process of wrapping things up after you pass away, can happen quickly and privately. So quickly means less cost, typically. Privately, you know, when I have a client who's passed away and their children come to wrap everything up, we typically have it all taken care of within about 2 months after the person passes away. You know, if we had to go to probate court, I'd still probably be waiting on a date to get the executor appointed. But with the trust, I'm already finished helping them. So that is something that appeals to many people, is how quickly things can be wrapped up. Yes, sir?
I just had a quick question. If you have a will and you have a trust, which one takes precedent? If there's a problem between the two?
Okay, if you have a will and you have a trust, which one takes precedent if there's a problem? That's going to depend on a couple of things. I have a will and I have a trust, so we'll talk about me as the example. My trust owns my stuff. It owns my house. It owns my bank account. It owns my car. So I don't even need the will. I don't care what the will says. So that's an example. But typically, if you have a will and you have a trust, guess what the will says? It says, if you need to use the will in court, pour those assets into my trust. So maybe you've heard the term a pour over will. That's what that means. That's referring to the fact that, hey, I have a trust, so if I forgot an asset, maybe I had just bought a new car and I didn't put it in the name of the trust and I pass away. It tells my will, pour that car into the trust. Because the trust is where I set out all the details and all the structure of what I want to happen in different situations. So, you actually do need a trust and a will when you have a trust. We hope we never need to use the will, but if we do, it says to pour everything into the trust. All right, let me talk about revocable trusts. There's irrevocable and revocable, okay? So I'm going to start with revocable. Again, this is like my husband and me. We have a revocable. We stay in charge, we can amend it, revoke it, change it, anytime the two of us agree to do that. Now, I can't go change it without him. We have to do it together if we make a joint trust. So you stay in control of your assets. It names a successor trustee. Let's say my husband and I are getting older or we pass away. We've already listed who's going to step in and serve as the successor trustee. That's kind of like the executor of a will. It avoids probate court, it stays private, nothing becomes a public record. But some of the other things that this revocable living trust can do, it can help protect my kids. So let's say my husband passes away first, because he's a man, he's older. And so I decide to get remarried later on. What does nobody want to happen? We don't want my new husband to end up with everything that my first husband and I worked together and built, and for our children to lose out, right? Right, I mean, nobody wants that, right? But that happens a lot. I mean, have any of you seen that happen to someone? Yeah. So, how does a trust protect that? A trust can have a provision, for example, like mine says, if my husband dies and I want to remarry, of course I can, but I need to sign a prenuptial agreement with my new husband. Because a prenup, a premarital agreement, that is how husbands and wives can change their rights to each other's stuff. Remember early on we talked about what happens, you know, your spouse can get at least half of everything under state law. So if you leave your new spouse out, you write them out of your will, the spouse can still come back and elect against the will or assert the state law and get a portion. So that's why, you know, prenups are so big in California, you know, things like that. They're not just for movie stars, you guys. If you want to protect your children from the event that you or your spouse might remarry someday, then that is a way that you can help protect them. I have many children bringing their parents into the office. They want mom or dad to be happy, but they also want to be a little careful about what's getting ready to happen. So that's a pretty common scenario that we see out there. It also can protect your children's inheritance. So let's say my husband and I pass away and we leave some money to our two kids. And when they inherit from us, they're going to be inheriting in trust. They're going to have their own trust with their name on it. And when they have their own trust with their name on it, they can put the money where they want. They can put it at Stockyards or Republic or Fifth Third or L&N. It doesn't matter what financial institution they put the money. It's about the name on the account. And if the trust name is on their account, the way that we write our trusts, their inheritance is protected if they get a divorce. If they get a divorce. If they file bankruptcy. If they have any judgments against them. Or if they have creditors coming after them. That divorce thing is the biggest concern I hear my clients talk about. So my kids' inheritance will be protected in the event that any of those things happen, just because of the language that's included in their trust. And trusts have lots of provisions that we call standby. We don't know if you're going to need them because we don't know what's going to happen in the future. So we include a lot of different provisions just in case. So I'm going to talk about some of those. I also want to mention a new law. I keep calling it a new law, but it's 2020, so it's already 5 years old. It's not that new anymore. But during COVID, a new estate planning law came out. It's called the Kentucky Community Property Trust Act. This is a new option for married couples. Okay, only for married couples. And this new option gives married couples a better tax benefit than if you didn't use this language. Has anyone ever lived in a state that's a community property state? If you have, you probably know. I mean, for those of us who've just lived in Kentucky, we don't know. But Arizona, California, Texas, Colorado. There's around 10 states or so that are community property states. And Kentucky's not. We're a separate property state. So what this law says is if married couples in Kentucky want to, they can treat their property in their trust like it's community property. There's one big upside and one big downside, married couples. The downside. If you get a divorce, you've agreed in that trust that everything's going to be split 50-50. Because that's what community property is. Equal. Okay. My husband and I have been married 32 years. I think some of you have me beat in this room, right? Yeah. Yeah. Is there any divorce going to happen here? No. You've already trained him. You have to train somebody else, right? Oh, he's not yours? You have your own. Okay. Okay. So the downside is something. I mean, I've got to talk to clients about that and make sure they understand. There is a downside to choosing this. So what's the upside? The upside is the appreciated assets that are owned by the trust get a full step up in their cost basis when the first spouse passes away. What's common, and what we're more familiar with here in Kentucky, is a half a step up. Does this mean anything to some of you? Are you like, you're speaking Greek, I don't even know what you're talking about, Cheryl. It's a tax thing, right? So I get into more details with clients about that, but I want your takeaway to be, there's a new law that gives married couples an option. So you want to understand the pros and cons of both and make an informed decision, okay? All right, let's see, let me talk some about irrevocable trust. I hear some people call it irrevocable, I say irrevocable. But tomato, right? Irrevocable trust. So one type of irrevocable trust is called a special needs trust. Have you heard of that before? Special needs trust? Those are common if there's a disabled person. Maybe there's some money, maybe go back to our car accident. There's a car accident, someone has a permanent injury, and they receive a large settlement as a result, and they're permanently disabled. So sometimes we'll create a special needs trust that money will go in. And we know it's there for the benefit to help take care of that person for life. Special needs trust. So that's a type of an irrevocable trust. Another type of irrevocable trust is what we refer to as a Medicaid Asset Protection Trust. We refer to those as MAPT, M-A-P-T, Medicaid Asset Protection Trust. These trusts can be used for a variety of reasons. One thing that, of course, we are all seeing more of in our community is more dementia, more issues like that. So in this type of irrevocable trust, let's say you've got a husband and a wife, and the wife has poor health, the husband's starting to have some dementia, and there's some concern that they're kind of not doing the right or the best things with their assets, or maybe they're worried they're going to get scammed and somebody's going to commit a big fraud on them, they're going to lose everything. Sometimes in that situation, if there's a good family support system, we might create an irrevocable trust. We might deed the house into the irrevocable trust. That way, the husband and wife that we're talking about can't sell their house, can't go get a home equity loan and drain all the equity out of their house because someone's just scammed them, telling them to send them $50,000 or something. So an irrevocable trust is used where you give up the power over certain assets of yours. You give up the power over certain assets. That's a big deal. So that doesn't work for everybody. It's not the right thing for everybody. Back to your example earlier, even some family members being taken advantage of by extended family members. These are a big deal, and they are not right for everyone, but they can be used to help protect assets. Let me talk about how they help in the Medicaid situation. Sometimes, let's say that we have a married couple and they're very concerned that they just don't have enough money to take care of the two of them for life. And they're really concerned about what is going to happen in in this situation. So there's no long-term care insurance and no big IRA and no tons of money in the bank, and they worry about how are we gonna pay. Sometimes in that situation, they will want to put some assets into this Medicaid Asset Protection Trust to start getting some protection in case they need some kind of care later on. It's a tool that can help people get Medicaid to cover some of their costs sooner rather than later. There is a lot to it. And again, it is not a good decision or a right decision for everyone. It's very case specific on what's going on in a situation. But if you've heard of that, that's a little bit about what that is, what that means. So you give up control of assets that you put into this irrevocable trust, and by giving up the control, it starts a clock ticking. Have you heard of the Medicaid 5-year look-back period? It starts that clock ticking. Because whether you just gift an asset away, you just give your kids $50,000, or you put the asset in an irrevocable trust, that act is held against you if you're applying for Medicaid coverage for 5 years. But then after that event has happened at least 5 years ago, it's invisible in that Medicaid application process. So that's a little bit about some of that you might have heard of in the past and wondered what it was all about. Okay? Okay. So I've talked about power of attorney, various healthcare documents. We've talked about last will and testament. We've talked about trusts, talked about revocable trust and irrevocable trusts. Okay? So what's next? That's kind of your primer on documents during life and then documents that you might want to have for death. So your next steps, I say go home and look at your current documents. Are they up to date? When you look through them, are the people that you've named as your power of attorney still alive? Are they people who you still trust? Look to see whether they still are current. Have your wishes changed?
Do they know that they've been named? Do they know they're your power?
That's a good
Do
point.
they know your
That's a good point. The people who you've named, who you would like to serve as your healthcare surrogate or your power of attorney, have you ever had a conversation with them to say, hey, by the way, I put you on my documents when I went to the lawyer's office a few years ago. That's a really good point.
I didn't know I was.
You were named on someone's and it came as a surprise when you were needed to do it? Yeah. Have you talked to them? Have your wishes changed? Maybe you prepared your will 25, 30 years ago. That was a different point in life, wasn't it? Now here you are. Maybe your kids are grown up. Maybe you've got some grandkids, or maybe you enjoy volunteering at a new place that wasn't part of your life 25 years ago. Is what you want to happen with your assets still the same now as it was when you prepared these old documents? And never handwrite changes on legal documents. That can result in that document being discarded or not accepted. So don't handwrite a change on a legal document. And do you have all of the needed documents? Did I talk about something today and you're thinking, I'm not sure I have that? Sometimes when I have clients come in, they'll have a will, a general power of attorney, and so I look and think, well, let's talk about the healthcare side. Do you have any healthcare documents? Oh, I think I might have done one, but I couldn't find it. Okay, we're going to need that. We need to find it, or we need a new one. So, do you have them all? So in addition to thinking about, do you have all the needed documents, do your loved ones have the needed documents? Is anyone here sitting there thinking about mom or dad right now? Or maybe your adult children? I mentioned to Doug that probably the average age of clients that come to our office are in their 60s. 20-year-olds and 30-year-olds are certainly not thinking about these kinds of things because the odds are so slim that they're going to need it. But if they do, they're going to wish they had it, right? So think about your loved ones, your young adult children, your own parents who they have. Because if they don't, you might be the one that's trying to make sense of everything and trying to get the authority and the power to help them because they didn't have documents in place. Another thing to think about is, do you have a plan for where you're going to go and how you're going to pay? It is sad sometimes, it's sad all the time when I see this happen. If I have a client who has, in my words, waited too long to make decisions. Now they are essentially homebound, a prisoner in their home, because they didn't plan or think ahead. This tri-level house is getting to be too much for us, all these stairs. So I encourage clients, think about these things while you can. Think about what would you want to happen if you started to have a mobility issue. Are you ready to find a ranch? Are you ready to find a patio home so that you can get rid of the yard work? Are you ready to just have a condo? So oftentimes, again, it might be the children who are calling me like, we've got to get mom and dad moved, dad's in rehab and mom's doing this. So I would just encourage you, make those decisions for yourself. Think about it ahead of time and start to plan what you would want your situation to be. So, it comes down, I think about this like our legacy. We all are going to have this legacy. We know through our Christian faith that we are created for eternal life. Our time here on earth is finite, but it makes a difference. The activities, your volunteer time, the resources that you save that are going to go to someone, it's going to make a difference. But for far too many people, all of that is just kind of lost in the wind because of a failure to plan. And 70% of families will end up in court, either because of the probate process or the guardianship process. That's a lot of people that go to court because they don't have the type of plan that makes things smooth for them when they become incapacitated or when they pass away. But you can take the information that you've learned here and move forward and take some of these steps to whether it is to avoid the probate process or if it's to inform your loved ones that you have them on their documents. Think about what is your next step based on what you've heard here today. And you make this hour that you spent here, worth something when you leave. Okay, so I believe that's the end of sort of my prepared material that I was going to talk about. I'm going to take questions. It is 4:28. So in my estimation, you're welcome to leave or stay, and I will stay as long as it takes to answer the questions that you all have. So I just have one question. Did you learn something today that you didn't know? Yeah? Okay, good. Then mission accomplished. Okay, question over here.
We talked about assets, what about debt?
Okay, debt. What about debt? Don't worry, you are not responsible for your parents' credit card debt. That's a question I get a lot. My parents have this credit card debt. Am I going to have to pay it? Not necessarily. Certainly, if you avoid the probate process, then there is no probate for the creditors to come forward and make their claims. Even sometimes with husbands and wives. Sometimes we see where one spouse has maybe incurred some debt that was separate, or maybe the spouse didn't know about. There could be times even then where the surviving spouse is not automatically responsible. But let's say a mortgage. Well, you don't just get to take the house and the mortgage disappears. You know, a mortgage has a security interest on that property. So yeah, the mortgage is gonna have to be paid off. When my mom passed away, I was trying to figure out, all right, she's been in the hospital many days, what are these medical bills gonna be like? And to my great surprise, there were hardly any. So I see that as a common thing that, oh, I don't know what these medical bills are gonna be like, and quite often, you know, they're at the end, they're not. So those debts don't automatically have to be paid. It depends on a number of factors like the ones that I've mentioned. Did that answer it, or were you wanting something specific that I didn't really cover? Yeah, okay. All right, what other questions? Any from the back row?
Other side.
Yeah, okay, over here, yes.
Okay, so I don't know anything about anything, so I'm gonna just talk stupid here.
Okay.
But if I have a trust
Yeah,
and I die,
yeah.
do my children who will be the beneficiaries come to you as an attorney to make it work? Or
Okay.
because if they are,
Mhm.
do they do it?
Mhm.
Does that make sense?
Yeah,
what
it
I'm
makes
saying?
sense.
I didn't
Yeah.
know how to phrase
Yeah.
that.
So if she has a trust and she's named her children the beneficiaries, when she dies, what happens? You know, do they come see an attorney, or do they just take care of it on their own? It varies. It varies according to what the assets are that are owned by the trust. But quite commonly, yes, you'll call an attorney. And my practice is, I say, what questions do you have right now? Because people don't want to wait, right? Like, just tell me, what are you wondering right now? Because that can go a long way, just sort of answering some of those things. And then I try to gauge with the new successor trustee, how much are they capable of handling on their own, and versus how much help do they want? Because I'll do as much or as little as what they want. I'll give an example. I had a family from a church, and their dad had a trust that he had prepared 20 years ago. Our office didn't write it. It was done a long time ago. So dad passed away, the 4 kids come in, I'm reading them, yeah, okay, looks good, I got it, yeah, okay, what's the trust own? It owns dad's investment account, his car, and his house. Okay, good. Have you guys talked about the house? Yeah, sister number 2 wants the house. Okay, everybody all right with that? Yeah, we've talked about it. Well, we have a question. What dollar value are we gonna put on the house? Like, that's a good question. Would you like my suggestion? Yeah. Said, I suggest you pay for an appraisal. And you tell the appraiser, we are appraising this for a family transfer. You know, then that appraiser knows, don't make it too high, don't make it too low, try to get it just right. And then the other siblings said, well, why don't we lower that number by 6% since we're not gonna need any real estate agents involved in this, which was very kind of them. And of course, sister was like, sounds great to me. So, you know, that's an example of what's very common. And I just prepare a spreadsheet. What's the value of the house, the car, the investment account, you know, put the columns. I prepared a new deed where we deeded the house from dad's trust to the sister who's taking the house. And then she just got less money than her siblings got. And again, we were completely finished within 2 months after dad passed away. So, you know, that's an example of if there's a bank account, a car, and a house, as to how it happens and how quickly it can be wrapped up. Yeah, don't you have a question?
Well, I don't know if this is on point or not, but I see this guy on TV all the time saying, don't go broke in a nursing home. What is he talking about?
So what he's talking about, he says the guy on TV that says don't go broke in a nursing home. So what he's talking about is, you know, that kind of long-term care does cost a lot. I mean, it's exceptional situation care, costs a lot of money. And so some people will spend everything they have paying that monthly bill. And so that notion is, are there ways to not spend everything? And that gets back to what I mentioned earlier with the irrevocable trust. and, you know, gifting some assets away or putting them in an irrevocable trust. And then later on, if you need that kind of care, you know, you're still paying and paying and paying until perhaps you reach the eligible level to apply for Medicaid to cover the cost. But even when you're in a nursing home, your income stream must always go toward your bill. So let's say your Social Security is $2,200 a month. And let's say you've got an $800 a month pension. And then you've got your IRA and you're over 73, so you have a required minimum distribution you have to take. Let's say that's $400 a month. All those things are considered your income. And even if you're having Medicaid help pay your bill, your income stream still has to go toward the cost of your care. So it's very specific, it's very detailed, it's very client specific, because for instance, maybe you've got a nice Social Security and pension and R&D, but your wife stayed at home and helped raise the children as her job, so she doesn't have any R&Ds and she doesn't have any pension, and her Social Security is pretty low. There's even rules for that, and where you can give some of your income to her so that she'll have enough. It's very, very case specific. But, you know, how do we pay for long-term care? Private pay out of your own assets and your own income streams. Long-term care insurance, which some people have a variation of that. And then Medicaid is supposed to be there when those things are depleted or when there's nothing else available to cover the cost. That's what that gets at.
What is that limit amount that you were saying, that you had mentioned with the Medicare?
What's the limit?
Yeah, you said you have, your assets have to be down to certain.
So if you're a single person, the asset threshold is $2,000.
Okay,
And you can have a car, even if you can't drive it.
it's not much.
If it's a married couple, it changes a little bit every year for a married couple. And the house is safe and secure because the one who's not in a nursing home gets to live there. There can be one car, and the dollar amount is about $150,000 that you can have. And also in Kentucky, this is, you know, Medicaid is a federal government program, but it's administered on a state-by-state basis. So it's different in Indiana than it is in Kentucky. So for example, in Kentucky, someone's IRA is not considered an asset if you're taking the RMDs out, you know, there's money being paid out, because that money being paid out is over here on the income side of the evaluation. But in Indiana, an IRA is considered an asset. So even this is very, very detailed and very specific state by state.
The other side of the coin is, okay, so I've fixed it all up so that now I can go ahead and apply for Medicaid. What choices am I gonna have about where I'm going to be? Because I don't think if you walk in and say, Mary, I've just applied for Medicaid, can I check into Nazareth? I don't even want to hear what the answer would be, because it's no in every facility in Jefferson County.
There's a limited, you know, there's lots of people needing things.
Let me clarify.
Okay, Mary's.
So that's not exactly right.
Really?
Some people may already be qualified for Medicaid, but when it relates to Medicaid being the primary payer for skilled nursing, you have to be in what's called a certified bed to start what the insider lingo is called spin down. So you can't apply for Medicaid for skilled nursing without being in skilled nursing, right? So all of our rooms are certified for Medicaid. That's just the way we're structured. When we purchased the Clifton location, it wasn't structured that way. So we still have some rooms there that aren't certified. We work with you. So this is a transparent situation. Yes, when you do come, we want to know what your situation is because we feel some responsibility there to help shepherd you through this process if that's needed. But with all the, I guess, commentary that's in the current narrative in our community about Medicaid, I just always want to say, it's not easy. It's not easy. It's a stringent process. And a lot of times you'll need help from someone like a Cheryl or someone who can really navigate. I've been here a long time. Back in the day, it was very simple. We had someone at the Commonwealth that was assigned an answer home and we could really help you. Now there is a huge burden on family to navigate this system, which is challenging. And I just want to put that out there. What I also want to put out there is in the Commonwealth of Kentucky, 67% of people who reside in skilled nursing centers are paid for by Medicaid. 67%. So, as Cheryl is saying, nobody wants to come to the nursing home. People make all kinds of plans to avoid the nursing home. And people typically are spending their private assets in multiple ways before you get to our door. Here, I'm going to give our plug. We have personal care, we have at-home care, so we have a lot of ways that we can begin to relate with you to help you manage your ultimate destination, and do that with keeping you in the driver's seat along the way. Thanks.
Yeah, I'm glad you're married for that, yeah. It's so true. Mary, were you in here when I said, in my office, I always say, now, Nazareth home, that's where you would want to be, so.
Yeah,
this is a wonderful
It's just like the end of days. There has always been a lack of desire to really talk about that, right? It's like these avoidable topics. So part of why we do these sessions is, like I said, 67% of the people living in nursing homes are being paid for by the Medicaid program. So that in and of itself is a story to tell, right? About how we're living in community. Yeah.
Okay, well, I appreciate you all coming. If you have something that you wanted to ask privately, like I said, I will stick around. And the next session
It's on sleep.
On
We're
sleep.
always here the third Wednesday of the month at 3:30.
Third Wednesday of
And
the
this
month
will
at
be
3:30.
April 23rd, Gretchen is telling me. So again, if you would fill out that questionnaire, that survey, and really pay attention to what you say you'd like to hear. And there's been a lot of people who wanted to talk about sleep, so that's what's coming up next month. So thank you again for coming.